Check out carmarshal.com. The link is in the description. They help support us.
Emails, photos stored in the cloud, and even your heart rate history from a smartwatch could be fair game, attorneys say, if the Supreme Court sides with the government in a potential blockbuster case headed to the court at the end of the month. When they return to the bench after Thanksgiving, the justices will weigh whether history of your cell phone location stored by a cell phone service provider is searchable without a warrant. The case centers on Timothy Carpenter, who argues the government violated his Fourth Amendment protection against unreasonable search and seizure when it obtained his location records from Metro PCS and Sprint without a warrant, and then used that data as trial evidence to convict him of a string of robberies at Radio Shack and T-Mobile stores in Michigan and Ohio from December 2010 to March 2011. The government argues that it is well within its right under the Stored Communications Act of 1986 to get a court order for the records. The law allows this type of data to be searched if the government can show reasonable grounds to believe it will be relevant to a criminal investigation. But beyond the law, the government is arguing that Carpenter lacks a legitimate expectation of privacy because he voluntarily turned his location information over to a third party when he signed up for cell service.
Justices to weigh cell phone privacy in landmark case. By Lydia Wheeler, November 23, 17:05:06 p.m. EST. The privacy of emails, photos stored in the cloud, even heart rate history from a smartwatch could be at stake, according to civil libertarians, as the Supreme Court takes up a potential blockbuster case after Thanksgiving. When they return to the bench after the holiday, the justices will weigh whether the history of cell phone locations stored by a phone service provider is searchable without a warrant. The case, Carpenter v. U.S., centers on Timothy Carpenter, who argues the government violated his Fourth Amendment protection against unreasonable search and seizure when it obtained his cell phone location records from Metro PCS and Sprint without a warrant. Authorities then used that data as trial evidence to convict him of a string of robberies at Radio Shack and T-Mobile stores in Michigan and Ohio from December 2010 to March 2011. The government argues that it was well within its rights under the Stored Communications Act, SCA, of 1986 to get a court order for the records. The law allows this type of data to be searched if the government can show reasonable grounds to believe it will be relevant to a criminal investigation. To obtain a warrant, law enforcement officers, however, must show there is probable cause. But beyond the law, the government is arguing that Carpenter lacks a legitimate expectation of privacy because he voluntarily turned his location information over to a third party when he signed up for cell service. It's a legal theory known as the third-party doctrine. Petitioner lacks any subjective expectation of privacy in phone company records of historical cell site data because they are business records that Metro PCS and Sprint create for their own purposes, Acting Solicitor General Noel Francisco, Acting Assistant Attorney General Kenneth Blanco and DOJ Attorney Jenny Ellickson argued in a court brief. American Civil Liberties Union, ACLU, Staff Attorney Nathan Fried Wessler, who's representing Carpenter, called the implications of that argument stunning. If the government's position wins, it would imperil the search queries people enter into Google or WebMD, our complete browsing histories showing everything we read online, the heart rate data from a smartwatch saved by Apple, a person's whole life in photos uploaded to the cloud and so much more, he said. In the 21st century we really can't go about our daily lives without creating these pervasive, highly sensitive digital records held by companies we interact with. The ACLU also argues the government is relying on an outdated law. Though it was updated in part in 1994, Wessler said the SCA really hasn't been touched since 1986. At that time there were only 1,000 cell sites in the US and less than half of 1% of Americans had a cell phone. Today, he said more than 300,000 cell sites exist and 95% of Americans have cell phones. But the government argues that cell phone location information isn't personal. As explained, the historical cell site records obtained in this case revealed only that petitioner, or someone using his phone, was in a 3.5 million square foot to 100 million square foot area when placing or receiving a call, the DOJ attorneys argued in their brief. The records did not, and could not, reveal any information stored on petitioner's phone or permit law enforcement officers to learn the sort of detailed personal facts. In a friend of the court brief filed in support of the government, the National District Attorneys Association warned the court against eviscerating the third-party doctrine. To do so would preclude SEC Securities and Exchange Commission and IRS Internal Revenue Service summonses for financial information necessary for their functioning and would bring a halt to countless state prosecutions dependent upon review of third-party records, including public corruption, identity theft, insurance fraud, and stalking, the group wrote. In Carpenter's case, the government was given 127 days worth of his location data from Metro PCS and 7 days worth from Sprint in early March when Carpenter's phone was connecting to a Sprint cellular tower in Ohio as part of a roaming agreement between the two companies. Police obtained 12,898 location points, one for the start and end of each call he made. But since the start of this case, Wessler said data usage has ballooned, forcing service carriers to erect more cell towers that are closer together, which makes data locations more precise. And since 2010 and 2011 when Carpenter's data was collected, he said providers have started saving location information for text messages and data connections in addition to calls, even when a phone is sitting in a bag or pocket and checking for emails or weather updates. Wessler said the ACLU acknowledges that police should be able to obtain some of this information within limits. Our position is that people have a reasonable expectation that police won't be able to create a map of longer-term locations, he said. That's a power police have never had to be able to assemble days, weeks, months worth of where people have gone. Where the line should be drawn between short-term data that's accessible without a warrant and long-term that requires one, Wessler said is for the courts to decide. Wessler said if justices need a cut-off point between short-term and long-term data, he suggests a 24-hour period. Oral arguments in the case will be held on Wednesday.
Hey Charlotte County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is you know, if I got, you know, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. You know, 47,000 of you so far right now. You know, $1 a day. I mean, $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.